The issue of artists' rights is again back in the spotlight. This follows the resurfacing of allegations that TS Records owes the late award-winning artist Zahara millions of rand in royalties. Now, to help us understand the legalese around the music industry, particularly music rights and how royalties work, we're joined by Osman Mkhondo. He is a lawyer from the KKInc Attorneys. Mr. Mkhondo, thank you very much for your time. The music rights and royalties. Just take us through a very quick crash course as to what is this when we talk about music rights and royalties, and how do the artists themselves benefit here?
Thanks, Mr. Polly, for having me. A very good morning to your amazing listeners. Look, it's easily complicated. Usually, there's two rights in every work. The first right will be your copyright in the sound recording, which is known as the master in the streets. Mm-hmm. And there will be copyright in the composition, which is known as the publishing in the streets. So now, usually when an artist gets into an agreement with a label, it will be split into those two rights. So the rights of the masters will then be discussed with the label. Then the rights of the composition will be discussed with the composers or even the co-composers. The problem becomes when one party then now wants to nibble from the other party's rights. So if you are entitled to the master rights, I really don't know how does it get to a point where now they nibble into the composition rights. We've seen instances, Mr. Foley, where some of the labels have their directors or maybe admin staff being registered as composers of some of the works, which is something that we've been trying to follow up and fix with most CMOs, and it's a long journey. But with royalties, there will then come a point where the music is sold. That's the first part of the royalties, where the music is sold and the money has to be split among the rights holders, which will be the master holder, which usually is the record label, and then the composers and then the authors of the work. Then comes the issue of publishing, where the composers have to be paid separately for that. Yeah. And that's where the money comes. Yeah.
Monetary terms, how big is this in terms of the actual money, the rights, the ownership of the rights, and the like? And I'm saying this on the back of a question I asked DJ Sbu, and the question was, would they be willing to basically hand over those rights, those music rights, to the family of the late Zahara as perhaps a peace offering, because she has been on several platforms complaining that her dues were not given to her. And long story short, DJ Sbu basically answered and said, look, that's something that I will have to discuss, because I also have children to feed. And so when my time comes that I pass on from this world, I would like to leave something for my children. And so I'm curious about just how big a financial benefit is this?
Look, with the copyright law in South Africa and maybe the other countries which we signed an agreement with through the Berne Convention, where the ownership of the masters, which is the sound recording, after time is in perpetuity, because the ownership of the second right, which is the rights in the composition, will last you even 50 years after your death. So you have those rights while you are still alive, and then you pass away, and then those who are left behind can benefit from it for 50 years post your death. That is why after the 50 years we have what we call public domain works, where anyone can now tap into those works and do remixes and do reworks, adaptations and whatnot, without really suffering a lot of copyright infringement issues. If you look at gospel music half the time, it comes with that. The songs were written years back, and the composers and the rights owners have now perished beyond 50 years. And now then anyone can work around it and use those. But now, when it comes to the masters, you have seen situations where big artists from abroad, like your Michael Jackson and others, would come back and say, look, I went back to my label, I went back to my publisher to buy back my rights. That is where the issue is, because you must understand, he who finances owns. So now the labels finances the creation of the sound recordings, which entitles them to ownership of the work. But now, in fairness, the ownership should be dual. It should be between the artist and the label itself, because both parties have invested their IP in it. And so the artist brings the IP, and then the label brings the commodities and resources to create the sound recordings. Unfortunately, I've seen cases and clients where the label will then take all the rights in the sound recordings and leave the artist with just a small portion of the sales.
Quick advice as we conclude our conversation. This is all very enlightening. The advice I asked of DJ Sbu is, what would you advise artists who are just breaking into the music industry? How do they protect themselves? And he says, get yourself an accountant and get yourself a lawyer. Those two are obviously not going to come cheap, but I suppose it is important that you have them on hand, because artists do at times get into trouble with the taxmen, SARS. Your biggest advice to an entry-level artist who is just getting in onto the scene?
Mr. Poli, I think we are repeating the same mistake where we put the responsibility on the creatives alone. We also have to put the responsibility on stakeholders, on record labels, on CMOs, and all the other parties involved. For example, we don't have a dedicated legislation for contracts in South Africa, but we expect artists to have knowledge of such. With the law of contracts in SA, we nibble from other legislations, we'll nibble from common law, so we don't have a forum where we can go back and say, wait, the parliament created this, so we can rely on that. That's number one. Number two, we need to have forums. The music workshops that we do now, we teach creatives how to make music. That's waste of time. Artists go to music labels because they know how to make music, but they need to learn how to turn their talent into business. So that is the forum that I'm talking about. Stakeholders should also change the approach towards artists. And then when it comes to artists, then we can look into them having to find themselves to sit with psychologists, to sit with financial advisors, to sit with tax consultants, because sometimes accountants are not really tax consultants. They can manage your money, but they can't assist you with tax issues. For example, if you ask me, why do we have collecting management organizations in the country like SAMRO and SAMPRA, but they do not have a platform where artists, in fact, a legal team where artists can go there and ask for legal advice for free? Those are the things that we need to look at. We need to try and avoid to put the whole responsibility on artists. We need to also have the stakeholders come on board. We need organizations like the CIPC to come through, because we find there are labels that comes and operates, and when liability becomes high, they deregister, vanish from liability. After the matter is off, they come back and register and operate again. So you see, it's the whole ecosystem. It's not just our artists not heading the call, but an accountant, a lawyer, tax consultant, good management, and CMOs who are supportive, and all these organizations that should support our artists without just waiting for us to go to them and complain when there's issues. They need to be part of the solution. Like I said, let's teach our artists how to turn their talent into business for longevity. Let us move away from teaching our artists usage. Let us teach them ownership.
Yeah. Osman Mkhondo, sage advice there. Thank you very much for your time and insights. He is from the KKInc Attorneys.